Be seated. Good morning and welcome to the First District Court of Appeal. We have 4 cases on the docket today. We're going to take a break after the first case and have coffee. There's a lawyer's lounge, which is directly to my left, your right, and that's where we'll be having the coffee. Before we begin, I'd like to extend a special welcome to Judge Schwartz. Many of you know is a very experienced judge, served on the Third District Court of Appeal, and before that, the Circuit Court in Miami. We're very pleased to have him with us this morning. Thank you. We'll call the first case Pelican Real Estate versus Boone.
Good morning. Charlie Wiggins for appellants Pelican Real Estate and Bill Smith. May it please the Court. Counsel, this is the second appeal in this matter. After originally a defense verdict in favor of my clients, Pelican and Mr. Smith, this matter was appealed to this Court. This Court affirmed the vast majority of the findings of fact and conclusions of law as rendered in the original final judgment, but remanded the matter back to the trial court on a very limited and very finite issue. And that issue was under the output standard as articulated in the written contract between the parties, whether appellee Richard Boone was entitled to certain compensation from my clients. After remand, after an evidentiary hearing in front of the trial court found that under the output standard in the independent contractor agreement, the contract at issue here, that Mr. Boone was entitled to certain sums. The issue on appeal before Your Honors today is whether the trial court on remand failed to take into account a critical provision in the contract. That is the provision that the broker, my client, could apportion compensation between 2 or more agents. In the independent contractor agreement, it discusses compensation.
That issue was before the court in the first trial and the first appeal, was it not?
No, sir, it was not.
Well, it was not made. It could have been and should have been if it were pertinent.
Your Honor,
if the first appeal had been affirmed in its entirety, you wouldn't have a separate case in which you could make this separate argument as to why you were not liable.
If I understand the Court, I think it's because the issue would have been moot and my client would have been pleased with the result. I mean, as a practical matter. The issue was not raised, or frankly, neither the output issue was raised in the original trial, as this Court well noted. Frankly, at the original trial, a review of the transcript shows that the parties were not necessarily convinced that they had a written contract. And if you read the original final judgment, the trial court was not necessarily convinced of that fact. It was this Court that made a finding on remand that the parties, and I think the Court's language was, this is a straightforward or this is a simple written contract case, and remanded for the Court to make certain findings under that written contract. Frankly, neither party nor the trial court made really any straightforward findings in regards to the rights and obligations under that written independent contract agreement at the first trial. I would submit
So to sit back just on one very, very narrow issue, and that is to determine the appellant's entitlement to the full real estate commission. Just on that one very narrow issue is remanded, right?
You are correct, Your Honor. Underneath the independent, under the written contract, and not under any implied contract or oral contract or anything like that. Yes, Your
and
Honor.
it says pursuant to the employment contract.
Yes, Your Honor. Part and parcel, we submit, of any evaluation of Mr. Boone's entitlement to compensation or commissions or anything else under the contract is that the trial court was obligated to therefore look at the entire contract and not parse it out.
The opinion didn't say anything like that. The opinion said for reconsideration of the issue of whether the sales were a product of the plaintiff's efforts rather than the procuring cause. That's it. There was nothing else that was called for in the first opinion. Did you move for rehearing on this ground that the issue had not been considered or whatever?
Move for a rehearing in front of this Court, Your Honor?
Yes.
No, sir, we did not. Your Honor, our position is that if we're going to go back on remand and perform an analysis of the rights and liabilities under the contract, it would be patently unfair to view one part of that contract in isolation to all of the others, that you can't look at that one portion.
There is such a thing as finality, both in the trial court and in this court. You can't continue to bring up new positions constantly. If what you say is true, that the first panel didn't consider all the items, the remedy is to call that to their attention in a motion for rehearing. But you didn't. And the mandate is perfectly clear. This is the one teeny-tiny issue that is to be considered, and none other.
Your Honor, there is no bigger fan of finality than my client, especially in this case in regards to some of the cross-appeal claims.
Finality, one person's finality is another person's death.
Yes, Your Honor. Ultimately, the reason that the issue of this apportionment mechanism, paragraph 3C2 of this contract, didn't come up is because it didn't come up in the original court. And frankly, again, my point here today is that you can't view any of these contract terms in isolation. That sort of runs afoul of how courts are supposed to look at contracts, that if we're going to look at one part of it, well, I think it's fair to everyone to take a look at all of it. And if, yes, Your Honor, if the primary focus is going to be under the output standard, that's fine. The Court did that. But he can't view that in isolation, and he can't fragment the contract. Under that apportionment mechanism, and I'll read it briefly for the Court, it says at paragraph 3C2 of the independent contractor agreement, if two or more associates participate in rendering a brokerage service to the public or claim to have done so, broker will determine in broker's sole and absolute discretion the amount of the fee due associate. The evidence before the trial court on remand.
Well, let me ask you a question now. The first case, the first DCA case, didn't suggest that there were co-agents listed, did it?
The opinion from this Court did not address that. There was testimony on that issue both at the original trial and certainly on remand. Your Honors, we believe that that language gave.
But again, that seems to me like you're expanding what the remand was for.
If we look at, I mean, the output language that this Court pointed to that was important to this Court is within that same paragraph. And we submit that it behooves common and legal sense to say, well, you have to evaluate this one part of the paragraph, but you have to ignore the other part of the paragraph.
Yes, but isn't that entire paragraph limited to a situation where you have more than one broker and you're trying to figure out how to split the commissions as opposed to a situation here where you have one broker and an in-house representative?
No, Your Honor, I believe.
I mean, I guess the in-house representative was, in fact, a broker, but that's not really the situation that this provision is addressed to, is it?
If I understand the Court's question, I would disagree. At the original oral argument in front of this Court, one of the issues that was addressed was whether the procuring cause standard, whether some of the case law that was being cited by the parties applied between brokerages, ABC Realty Company, XYZ Realty Company, or whether you could apply those same standards.
That was discussed. That's the issue that was discussed?
Yes, exactly. This paragraph, we believe, under the plain reading of it, doesn't apply between ABC brokerage and XYZ brokerages. Under its plain meaning, it applies to agents within a single brokerage. Example, which is frankly the example we have here, you had, I think, 3 agents, Mr. Boone, Karen Oliver, and Lisa Johnson, all claiming entitlement to the same commission. And therefore, it is this provision that allows the broker, in his sole and absolute discretion, to apportion those. Now, as we've noted in our brief, that discretion is not boundless. It cannot be unreasonable. Some courts have referred to it as arbitrary. Some courts have referred to it as capricious. Some courts have said you have to be commercially reasonable. The evidence before the trial court we submit was uncontradicted that it was commercially reasonable, it was not arbitrary, and it was not capricious, therefore giving right to my client to apportion those commissions at issue, these 15 commissions, between Mr. Boone and the other 2 agents who were involved in these.
Your client is not interested in this issue.
I'm sorry?
Your client is not interested in this issue. The only people interested are the plaintiff in this case and the other 2 persons.
Respectfully, Your Honor.
You're paying the same commission. It's just the question of to whom you're paying it. I'm not even sure that you have standing to raise the question.
I respectfully disagree, Your Honor.
I'm not surprised.
My client is interested because it now has a judgment against it for the better part of $100,000. If these agents, amongst whom my client had made this apportionment, had been happy with that apportionment and said, I'm going to go on my merry way. I'm happy with that apportionment. I'm not going to gripe about it to my local courthouse, we wouldn't be here and we wouldn't have standing. Unfortunately, Mr. Boone did have a gripe about it. He does not agree with our position on this regard, and now we're asking this court to do the right thing, which is to vacate the money judgment against my client. Your Honors, with that, I would like to reserve the balance of my time for rebuttal.
All right. Counsel, you have a cross appeal, and you have a right, I suppose, to reserve a little time for rebuttal on the cross appeal, if you wish to do that.
Yes, Your Honor.
If you do, the argument on that point will be limited to any comments that are made regarding the cross appeal.
Thank you, Your Honor. I would like to reserve 2 minutes on the cross appeal.
Go ahead. You may proceed.
May it please the Court, I'm Robert Beasley. I've represented the Boones in both the trial, the first appeal, and now the second appeal brought by the appellants in this case. The appellant's new argument, as presented in the remand case, and it was somewhat presented in the first case, is dependent on a misunderstanding of the split of real estate commissions. There are sides. There are 2 sides. There's a listing side and a selling side. Boone was the selling agent, which means his entitlement on the 70-30 split is on this side. He was identified as such in all records of Pelican to include the contract. Lisa Johnson and Miss Oliver, they were the listing side. They actually were the Pelican presence in the office on the site. Mr. Smith, as the broker, wasn't sitting there. Miss Johnson and Miss Oliver were sitting there. Pelican, this was an in-house listing, which means Pelican got the listing side entirely. Miss Johnson and Miss Oliver testified that they were paid out of that Pelican side, rightfully so. In the forms that you see, Miss Johnson and Miss Oliver's name are pre-printed as the Pelican representative. So they got paid out of the listing side. Mr. Boone claimed his 70-30 split out of the agent selling side. He brought the buyer to the transaction.
Was he the only one listed as a sales agent?
He was the only one listed as the sales agent. Any form in which Oliver and Johnson's names were also there, they were listed as the Pelican representative. And I will note that the pre-printed reservation forms, because it went to reservation first, then first contract, then first contracts were rescinded. 40 of them went to first contract. They were rescinded because of the Land Sales Act. The project wasn't done in 2 years. Then 26 of the 40 re-signed, and 26 of the 40 re-signed and then closed. By the time they re-signed and Mr. Boone was identified as the sales agent, 2 things had occurred. One, Mr. Boone had been a licensed Florida agent for 2 years, and 2, this lawsuit had been ongoing. And by the time they closed, the lawsuit was ongoing. And thus interjects the new argument, which is that it's in the broker's sole discretion. One of the salient points in front of the trial court was that this sole discretion was one unique from any other arrangement that any other agent got, which was no one else had to share their commissions with Oliver and Johnson because they were compensated fairly out of the listing side. And 2, it was exercised as discretion during the pendency of a lawsuit in which Mr. Boone had sued, keeping in mind that this court should recognize that 98% of the lawsuit had nothing to do with Tidewater. It actually had to do with what we call the Williams transactions. when the trial court erred in applying procuring cause, thus causing an agent to compete with his broker by the law, the trial court applied that to everything. The 97% of the case that we were there for, which were the Williams transactions, and the Tidewater transactions. On the remand, the court considered not just the Tidewater, but also just 15 of the Tidewater. For some reason, yet to be determined by anybody that I know of, is there were 26 of them, and the court only looked at 15 of the 26. That's the subject matter of our cross-appeal. The other subject matter of our cross-appeal is that the bonuses, paragraph 3C2 is what's being described here as their opportunity to deny Mr. Boone these commissions. But 3C3 says under incentives, if the seller pays an incentive, bonus or other incentive, in the form of money, it will be paid entirely to the associate. The contract says so. Tidewater paid $2,000 and $2,500 incentives, undisputed.
If the trial judge had gotten into that issue, though, would that not have been beyond the scope of the remand? What the court was directed to do on remand?
Well, the question is whether or not that incentive was part of the compensation due to the agent. And all other agents received both the bonus and the commission.
But that's not the issue addressed by the court. Perhaps it should have been, and perhaps you should have pointed that out to them, as again, on a motion for rehearing. But you're on the same petard that your opponent is on another issue. The word bonus doesn't appear in this opinion.
And the word bonus was ignored entirely by the trial court on the remand.
Yes, for good reason.
It seems as though the bonuses escaped this entire case, as if they were never paid and
And
received
it's
by Pelican.
your position then that in determining the commission, the court should have considered what bonuses are part of the commission also.
In the case where the seller paid a bonus, the bonus was added to the commission in all cases, because it was a flow-through by contract and by practice. And so when you receive your commission check, it would include any flow-through incentive bonuses. And in this case, these bonuses were paid. They were paid to Pelican. They never made it to Boone. They were part of the damages claim. And so
But they were not awarded in the first judgment either, were they?
Well, nothing was awarded in the first judgment because the judge applied procuring cause and said Boone wasn't entitled to anything because he wasn't the, quote, procuring cause of these transactions. Of course, that is the third point of our appeal, our cross-appeal.
Can I back you up just a second and ask you, detail for us, please, everything that should have been included in the commission?
The commission is strictly the split of whichever side. In this case, because it was in-house, the contract called for it to be a 70-30, and of the selling side, because Mr. Boone clearly was not a listing agent. And in the event, and it's under compensation 3C, and the very next segment says that if there's a bonus paid, it flows through.
So the commission is the split plus any incentive or bonuses.
That's right. And the bonuses, these days, the developers were paying these bonuses as a part of what they call the incentive, and it was coming out of the developer's profits. It was going into the commission. And it was to get their project preferred, if you would. And it was undisputed that in all circumstances when they were paid, in fact, there's another project that the trial court heard about called Calypso. Those bonuses were paid. They did go through to Mr. Boone and the commissions, but that was prior to the lawsuit being filed. And so what you have is this line in the sand when Mr. Boone, after the lawsuit was filed, he doesn't get paid his commissions anymore. He gets recategorized and so forth and so on. The trial court really didn't focus on any of those issues, though, because once the trial court determined that Mr. Boone wasn't procuring cause, then all issues of his commissions were disregarded. And that error essentially was the thread through the entire case, was if Mr. Boone wasn't the procuring cause, then he wasn't entitled to any bonuses or commissions on the Williams transactions or the Tidewater.
Was he paid? You complained about not being the trial court on the remand not being concerned with the transactions after he became a licensed broker in Florida. Was he, in fact, paid for those amounts?
Well, that's the mystery, because the evidence before the trial court was that there were 11 of them.
Yes.
Okay. That 2 of them he wasn't paid at all. And the rest of them, he's paid varying amounts on this referral fee basis. So the same premise of he's a referral agent applied to those 11 as did the 15. But the line drawing was done as an opportunity to cut out 11 by the defense counsel on this idea that they were pre or post. The issue that's fundamental to that is they were all post because they were all re-signed in 2003, and the Boone Appellate Court, Boone 1 as I call it, determined that to be the case. Because it no longer mattered whether they were pre or post. That would only apply to the referral situation. Then 2 years passed. Then all 26 were post. All 26 were signed in 2003, 2 years after his license. So that line was just arbitrarily drawn to exclude 11 transactions, which would cause this judgment effectively to be twice of what it is at this point, because there's 11 more transactions which commissions, full commissions, were not paid. And bonuses were not paid on any of the 26. The interesting thing about this split that's going on is that there were a set of records maintained by an independent broker. Tidewater hired another agency called Resort Quest and a lady by Linda McKnight, and she maintained administratively all contracts. And she constantly sent her records to Pelican, and they were checked and they were cross-checked. And on those records, the only independent person in this dispute, Mr. Boone, is the selling agent on all of them. And these were
And the only selling agent?
The only selling agent. And she she was in charge of the project, and she said who got paid what, and her records were cross-checked through Pelican. In fact, she got her info from Pelican. But when the dispute came out, when the lawsuit got filed, no one could get to Linda McKnight and change her records. And so when she comes into the court, she says, I administered the whole project. Well, who was the selling agent? And she read them down. Mr. Boone, Mr. Boone, Mr. Boone, on all 26 of them. And so from the objective administrator's point of view, there was never a question. From anyone else's point of view, there was never a question about the role of Linda Johnson and Ms. Oliver. And they couldn't go so far as to support the defendant's position. They couldn't go so far as to say, I think I was entitled to Mr. Boone's commission. What they said was, I helped Mr. Boone's clients. I did. They came and I helped them pick out fabrics and I did those things. They did the exact same work that they did for everyone's clients because they were on site, they toured the facilities and so forth. And this was the efficiency. Pelican's listing side, they got half of the commission for something. And what they got their half from was the actions that they did, the work they did on site. That is completely different from the work that the buyer does, buyer's agent. I call them the buyer's agent. Technically, the industry term is they're the selling agent. But that brings the buyer to the transaction. And so what we have is
prior to the lawsuit and prior to the first judgment, your client got how much on any of these 26 transactions? Did he get paid prior to the lawsuit or irrelevant to the lawsuit? Did he get paid anyway? And how much on, was there a distinction as to whether he got paid on the first 15 and the second 11 or anything like that?
No, there's two independent variables here. There's the lawsuit, then there's the closing schedule at Tidewater. And none of the Tidewaters closed before the lawsuit. Some of them started to close during the lawsuit.
Well, I'm really asking, did he get the money? He doesn't need a judgment if he's already gotten the money. How much money did he get from Pelican as a result of his efforts on these 26?
The evidence before
he
the
said
trial.
He got nothing from the judgment, the first judgment, but how much did he get other?
The evidence before the trial court, and there was a schedule produced that he did receive varying amounts on some of the earlier Tidewater closings, but they amounted to this referral fee concept in which the broker at his own discretion reduced it to 25% from 70%. And so the position of the broker was, I've paid him on those 11. Well, he did pay him, and he did receive money, and there was an accounting for that money. The judge had a table. He was due X, he got Y, and so he's short Z. And that table was very much in front of the trial judge, truthfully, at the first trial and then the remand trial. And so it's hard to even imagine a situation where the trial judge takes a line and says 11 don't count and 15 do. And the only support for that is that the initial reservations, 11 were prior to and 15 were after. But that's long since water under the bridge when you consider that they were all 26 were signed in 2003. So that line is completely arbitrary and it really has no application at all. The trial judge has the information.
And it's not related to his becoming a broker in Florida.
It is in what the defendant's position is that's what it is related to. The problem is that the appellate court, when it reversed the first time, found that at the time of the re-signing of all 26, he was a broker by 2 years. And, I mean, he was an agent by 2 years in Florida. So that issue becomes
what does the first opinion mean when it speaks of certain Tidewater transactions?
There are Tidewater transactions which were not being claimed that he was paid the commissions on. And so there's some dividing lines there on what was and what wasn't. Again, this info was available to the trial judge in a very clear tabular form. And so it was just a matter of reaching a total. But once you start drawing lines, the trial judge intentionally said at the outset of the proceedings, I am only looking at these 15. And so the 11 were out from the beginning of the proceeding, as if that pre- and post-reservation time back in 2001 was significant. I'm into my rebuttal time, but I'll be glad to discuss any questions.
Without going into the gory details, the record is the record, and we dispute vigorously some of the factual assertions that Mr. Boone's counsel has made here today, specifically in regards to whose listing it was and the listing agreement for this Tidewater project. There's one fact that I would like to emphasize to the Court that has been a hallmark of Mr. Boone's arguments, and that's the testimony of Linda McKnight, who did coordinate certain things. She kept her records. She was not an employee or an agent of my clients. She has no idea, by her own admission, how much Mr. Boone was to be paid, or the commissions that he was to be paid, or how he was to be compensated for his work for my client.
Her list was just setting forth who the agent was?
She was keeping track of the sales. That's all she was doing. Past that, she has no idea internally what was going on with my client. I would like to address some of the matters that were raised by Mr. Boone's counsel. To answer Your Honor's question as to how much Mr. Boone was paid on this Tidewater project, those amounts are broken down both in the original final judgment and the amended final judgment. Roughly, he was paid over $100,000 for his work. This is not a circumstance where he has been paid nothing for these efforts. He's been paid a relatively large amount of money. Let me move on, and I'm a little bit all over the map here. The Court inquired as to the bonus versus commission issue. We submit that bonuses are in the form of compensation, but they are not per se a commission. They are two different forms of compensation.
Does a commission include the bonus?
No, ma'am. And, Your Honor, to answer that question or to bring that issue home where we are on this appeal, we would submit that as it relates to bonuses, that issue is fully encompassed by paragraph 3C2. Paragraph 3C2, we contend, covers both commissions and bonuses or any other form of compensation there might be coming into the brokerage. Obviously, one of the primary issues that Mr. Boone has in this is what was the proper scope of remand as it relates to these Tidewater units? Was it 27? Was it 15? Was it 11? We can talk about law of the case all day long, but I'm fairly certain that this is the case. That issue was vetted extensively at the original trial court. It was discussed ad nauseum.
Well, what is the basis for it? There's no question that a distinction was drawn between the 15 and the 11, correct?
I agree with that, Your Honor.
What was the basis for the distinction?
The basis for the distinction was this. Mr. Boone, prior to obtaining his Florida license, referred 15 Tidewater purchasers to Pelican. He referred another 11 after he obtained his Florida licensure. Of those 15, he got them on the hook, so to speak, before he got his Florida license. Nobody was able to reel them in, and I'm sorry for these crude terms, but it may be appropriate here, until after he got his licensure. And as the testimony showed again and again, both at the trial court the first time and on remand the second time, internal policy, and it's not necessarily disputed by Mr. Boone, is that once you're a referral agent, you're always going to be a referral agent, and meaning a referral agent is going to get a certain sum of money throughout the history of the sale, regardless of whether you get licensed midstream. And that's a sense of fairness to the other agents who might be assisting with that, who would necessarily have to assist because Mr. Boone was not a Florida agent. I want to circle back.
That would mean he would get more. No.
No, sir.
He would get less for the 15 than for the 11.
Yes, sir. And the difference.
Did he?
Yes, sir, he did. And the difference was this. He got a 25% referral fee, or 25% of the commission. Call it a referral fee. It's 25%.
Okay.
For those sales that he procured or his output for sales after he was licensed, he got a full 70%. That's the rub in this case. My last point is that the issue of what was encompassed under procuring
costs. So there was no doubt that he got more money for the 11 than he got for the 15, correct?
That's correct, Your Honor. Yes, Your Honor. These issues were resolved in this Court's, meaning the scope of remand was resolved both in this Court's original opinion, and we cannot forget that there was a motion for clarification filed by Mr. Boone afterwards as to this, is it procuring cause, is it output. That motion was flatly denied by this Court, and we think the Court was correct in that decision. Thank you.
One of the problems in this case from the inception in Crestview, Florida, Phoenix Springs, Florida, when we tried to do the numbers, and you said that you heard that Boone got $100,000 in commissions. Pelican received $8 or $9 million in commissions, plus a split of $130 million profit off of one of these projects. So when Boone brought Williams down from Atlanta and Williams invested his $100 million in the beach, then Pelican received the benefit of all of that. And Pelican was the listing agent on some of these major projects because Williams put the money in, and Williams was the client of Pelican that Boone brought down. The trial court said, Boone, you weren't the procuring cause because Mr. Smith took over the relationship and he worked with Williams. Well, of course he did. He was the broker. But requiring the broker to compete with the agent is improper, and the first court considered it such. Now, so you got Pelican receiving millions and millions of commissions and then hundreds of millions in profits that were split. And Boone got a piece of his original 26. Now remember, this lawsuit was not even filed about Tidewater. Tidewater had not manifested into commissions at the time the lawsuit was filed. The lawsuit was filed 98% about the $100 million worth of investment that Williams brought down. Then Tidewater starts to roll out during the course of this lawsuit, and you see these various reasons why Mr. Boone doesn't get paid on Tidewater, which was really the small fish. And now Mr. Boone's left fighting for the small fish and half of the small fish that he didn't get to start with. The fundamental error in our cross appeal is that when this court said procuring cause shall not be applied, you go back and how do you ignore 97% of the case where you applied it? And then we're now defending an appeal on the remaining 3% of the whole case in which we only got 1.5%. These numbers are big, but they were big all the way across the board. They were big in Panama City during that period of time.
But you raised the 97% on the first appeal, and that was affirmed.
We raised it on the first appeal, yes, Your Honor.
You raised it in the first trial, you lost, and you raised it on the first appeal, and you lost.
And on the remand, we asked the court to consider the misapplication of procuring cause throughout the whole case, because the case is lost at the start when you make that legal decision. You certainly must concede the first opinion speaks only of certain Tidewater transactions, nothing else. It does, Your Honor. The first opinion.
And everything else is specifically affirmed.
The first opinion is absolutely down the line in our favor until one little insertion it says on those Tidewater units. And for some reason, that insertion then directed the trial court to focus on the error of procuring cause on what I call the small fish. And we ignore the whole status of the lawsuit. Thank you.
Thank you, counsel, and thank you both, counsel. We will be in recess now, and as I said earlier, we invite you to join us, counsel, to join us for coffee in the lounge to your right.